Hello and a warm welcome to Personal Finance. I'm Gugulethu Cele. Joining me tonight is David Crossley, not only a certified financial planner, but also the business manager at BDO Wealth Advisors. Now, this is to give insight into a conversation which can be a bit tricky and challenging at times, given the fact that losing a loved one can always be a difficult experience, but even more so when stress is added as you have to deal with the deceased estate. So to give us insight into this, David, thank you so much for joining us and for your time this evening. Let's perhaps pick up on the importance and relevance of an estate executor. Just exactly how important are they?
The estate executor is very important. There are two sides to things. The estate executor is appointed in terms of the will to administer the assets and liabilities of the deceased. That, generally speaking, is in terms of a will, but every now and then somebody dies without a will, in which case then the executor is appointed by the master, and they then have to do the same job. They have to bring together all the assets and the liabilities of the deceased. They have to deal with the family. They have to then create the letters of executorship via the master of the court. And from there, they accumulate the assets and liabilities onto what is called a liquidation and distribution account. And there's a constant communication with the master, because the provisional liquidation and distribution will go to the master. He may have queries about it. There may be property to sell. There will be movable property that needs to be disposed of. There will be certain items that may have been specifically put into the will as inheritant item for various members of the family. And the process can take a relatively short time depending on the complexity of the estate and the size of the estate. Or if there is no property to sell, then there may be a very, very short period of time, shall we say 6 months, before everything is wound up and the master is happy that everything has been dealt with correctly and the proceeds can then be distributed to the heirs.
A very complicated process, as you've alluded to, but let's perhaps take it 2 steps back by picking up with the will. When a will is in place and an executor is appointed, but what if it happens to be a family member? I understand dealing with the pressures of losing a loved one is already too hectic, but some people might find that they find comfort in their sons, daughters, wives, or other relatives actually executing this estate. Would that be advisable?
Yes, I think it would be advisable, because the one advantage of appointing a family member or a very close family friend as the executor on your estate is that there is empathy, there's care, and a great deal more time and effort will be done in terms of doing what the deceased would have wanted to see done. A lot of people will do a will through a bank, for example, and the banks do a very adequate job of winding up estates, but it's a relatively disconnected way of doing things. So, they will just do what they have to do. But a member of a family or a friend, ideal person to nominate as an executor. However, having said that, if you nominate your wife or your husband to be your executor, then the issue of emotion comes into it.
True.
And that may colour a person's thinking when it comes to dealing with the estate. You need to keep the emotion out of it. You need to be completely objective when it comes to dealing with the proceeds of that estate.
Then talk to us about how they need to handle some of the technical issues. And I take it this is exactly the point in time where one would seek professional advice from an executor. How do you identify them?
You will find that the majority of attorneys will also administer an estate. Accountancy firms will administer an estate. And in the case of BDO Wealth Advisors, we have a separate division that is totally dedicated to the administration of estates. So we have 2 highly qualified administrators and an admitted attorney who help with the creation of the documents, putting everything together. They will liaise regularly with the family, particularly the executor, because the executor is still the one who has to make all the decisions, but they will advise the executor. And the one big advantage of using somebody who's not the executor to do the actual administration is that it is a more separate situation. There's no emotion involved, and a very objective viewpoint can be reached. So the advice is objective, and the executor would do well to listen to that advice.
And I take it they can also deal with some of the technical terms as well as legal elements such as estate duty, I understand, depending on the threshold and the size of this particular individual's estate.
Absolutely. Things like estate duty, how to sell the property correctly, how to be in a position to say what delays are going to be there, legal advice. You may have siblings who are at war with each other. You may have all sorts of situations. You may have previous spouses, and that sort of thing needs to be dealt with rationally and objectively and very unemotionally in order to make that estate come together into that final liquidation and distribution account, which the master will then approve, and he will then issue a filing slip, which means I'm happy, you may now distribute, and the estate can be put to bed.
I'm glad you mentioned the thorny issue regarding tense family relations, which often happens. Are there ways of dealing with this without necessarily ostracizing particular family members, or does the executor require full disclosure from all participants to ensure that the method is seamless?
I think here we have to differentiate between the agent who's administering the estate and the executor. If there is a family squabble, shall we say, people will always say, we will never fight. Children will never say, we will never fight about the proceeds of my father or my mother's estate. But in reality, when the person dies, there's generally speaking a certain amount of discourse between the people. And the advantage of having the agent there, they will deal with this particular family member, then maybe deal with this particular family member, and create a mediation atmosphere, if necessary, in order to bring the whole thing together to a final conclusion. So, in my opinion, you know, and I've seen it work at BDO with the division that we have, we wind up that estate. We have the expertise, as do many attorneys. We know who to go to, and that's the key. If you know who to go to at the master, if you have conduits to make things work, it happens much more quickly than if you try and do it yourself. If you're in doubt about that sort of thing, try selling a house on your own. Do you perform root canal on yourself? Do you rather go to the dentist? Do you go to the doctor when you're sick? Would it not make sense to go to a professional to deal with it and pay them something to do it?
Exactly.
That's what I believe.
Exactly. If you want things to be done efficiently, then perhaps that's the route to go. But talk to us about the fees and costs that might typically apply here. Is there an industry standard or average?
There is an
perhaps?
industry standard in terms of the Estates Duty Act. The fee that the executor earns is 3.5% of the value of the estate plus VAT. Now, if typically with a situation regarding us at BDO Wealth, what we will do, if it's a very large estate, we will negotiate the fee. And it also depends upon the complexity of the estate. For example, the will may contain provisions for a testamentary trust. There may be trusts in place. There may be multiple properties in South Africa, and there may be properties overseas. So as we look at the complexity of the will and as the complexity of the estate unfolds, then we will gauge the appropriate fee that goes with the amount of work that we have to do.
What happens if the estate has more liabilities than assets? How is that fee calculated then?
Well, it's you know, there is still a fee that is put into it. You know, just because the estate is technically insolvent doesn't mean to say that the person who's administering it shouldn't receive some money.
Sure.
It's a difficult situation, and I'm trying to think of an example. We have dealt with insolvent estates, but an insolvent estate is insolvent because the liabilities exceed the assets. And in that case, if you're the executor and you're winding up the estate, you may very well waive your 3.5% fee because you're a member of the family. But the fact is, there is still going to be an insolvent estate, and that creates a whole separate set of problems.
Goodness. And again, like you say, needs the professional advice and all the structures in place to understand how to navigate the process.
It does, because one of the things we do when we wind up an estate is we advertise. And we say, does anybody have a claim on this estate? And people out there who hopefully read the papers will be given a certain amount of time to come forward and say, yes, we have a legitimate claim on that estate. So maybe the executor doesn't know about that. Maybe the executor, who may be the wife or a sibling, doesn't know that the deceased signed a surety, for example.
Exactly.
And it's much better if that comes into a different area and can be dealt with dispassionately and put together as part of the documentation. Bearing in mind that if we are an agent for an estate, we will be in constant contact with that executor.
Precisely. Well, we've certainly heard quite a bit, but let's get some of the key takeaway points from tonight's discussion. David, perhaps provide us with a quick roundup of some of the key considerations that our viewers need to leave the show with tonight.
I think first and foremost, make sure, if everybody's alive and kicking now, make sure that everybody has a valid will and that the will is comprehensively laid out and that there is absolutely no question or problems regarding what is going to happen to assets. And if that means that I'm going to have a shopping list at the end of my will that says I leave my signet ring to my son and I leave my watch to my daughter, then you do that. Because when I die and the papers are opened, if everything has been demarcated and itemized, there's very, very little chance of family sort of strife and things like that. So that's the first thing that has to happen. Mm-hmm. It's a very good idea before you die, and it's all very well to say this is after the fact, to visit a financial planner and say, if I died now, what is the state of my estate? And that financial planner, and any competent financial planner will be able to calculate for you exactly what your estate situation is. Do I have an insolvent estate, for example? Am I going to have a liquidity crisis to leave for my heirs to deal with? So then what a financial planner would do is say, well, why don't we take out a bit of life insurance to cover the liquidity shortfall? Sure. So if that is all in place and the person dies, the estate can be wound up efficiently, cleanly, all creditors will be dealt with appropriately, the liquidation distribution account will be correct, it'll go to the master, and it will come back with minimum queries. And that's what we want to see. And I've been party to a couple of estates where the will was correctly put together. And even with property incorporated in that estate, it took about 6 to 7 months to wind up. So it's not impossible, but it was done by an agent at BDO Wealth where we know what we're doing.
Exactly.
Yes.
But, given the long lead times that you've described here, 6 to 8 months, are these industry averages and standards that we're working with, or could it take even longer?
It can take a long time. There are estates that have been in a process of limbo for 10, 12, 15 years sometimes.
Goodness.
And the reason for that is, in my opinion, is because plans were not made at outset. This is a very, the society that South Africa has come from, very much the head of the household controlled everything, including the money. And very often the wife and the family didn't know the financial situation. So in a situation like that, the wife is left as possibly the executor, and she knows absolutely nothing about the financial background of her late husband. That creates even more complication. I think we've come a little way since then. I would like to think that husbands and wives and their children talk and share information when it comes to where the estate will be in the event of a death of the husband or the wife.
Well, we'll wrap it up on that note for personal finance tonight. A big thank you once more to David Crossley, Certified Financial Planner and Business Manager at BDO Wealth Advisors, for updating us this evening. Remember that we'd love to hear from you, so get in touch. You can tweet any of your comments and suggestions to @CNBC Africa using the hashtag Finance410, or to myself @Gugulethu on Twitter. Until next time, have a wonderful evening.